Okay, we are on the record as the people of the state of Michigan versus Deontay Markel English, case 1259967. Mr. English is charged with one count of buying and selling stolen non-ferrous metals. First offense set for an exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Deontay English, P80517.
Attorney Perlman, can you say your name and P number again? You got cut off.
Yes, good morning. Jeff Perlman on behalf of Deontay English, P80517.
Thank you. And Mr. English, can you state your full name for the record, please?
Yes, ma'am. Deontay Markel English.
Okay. They set for an exam. Are the people ready to proceed?
They are not, Your Honor. The people do not have sufficient evidence to proceed.
Okay.
Judge, I would motion to dismiss on that.
I will dismiss without prejudice as the people are not ready to move forward. I will have the dismissal form scanned over to you, Attorney Perlman. Your case has been dismissed, Mr. English.
Okay, thank you very much.
Thank you, Judge.
You can log off, Mr. English.
Okay.
Attorney Brush.
Good morning, Your Honor.
Good morning. Ready to call Shelton. Are you ready?
Alexis, I'm here for Alexis Tyson.
Oh, I'm sorry.
No worries.
Wrong person. Let's type it. Right. Okay. Calling case 2356235, the people of the state of Michigan versus Alexis Kai Tyson, charged with one count of weapons carrying concealed, and also a misdemeanor count 2 weapons, pistols carrying concealed while under the influence, set for a probable cause conference. Today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush, P number 85828, appearing on behalf of Alexis Tyson, who is present via Zoom today. Ms. Tyson, please state your name for the record.
Alexis Kai Tyson.
Thank you. Okay, Attorney Brush, do you have discovery?
I do, Judge.
Okay. Any other preliminary matters before the exam date?
No, no, Judge. We are ready to set this for a preliminary exam.
Okay, so can you do May 16th or 17th? Attorney Brush?
I was just checking my calendar. I can do May 17th later in the morning.
Okay, it'll be a long day. I have 9:30 open, but since you need later, I'm trying to squeeze you in before we have a training on Thursday and Friday. We're not available, so I want to squeeze your case in before we go to training. Let me see.
I can try to make I think I can make 9:30 work.
Okay, and just let us know if you are running late. We'll be here all day.
Okay, I will.
Okay, so Ms. Tyson, your exam has been set for May 17th at 9:30 a.m. in person at 36th District Court. You understand that?
Yes.
Okay, anything else from either party?
No.
No, Judge.
Well, have a good day.
Thank you.
You too. You can sign off, Ms. Tyson.
Okay.
Mr. Andrew Love, I believe.
Yes, Your Honor.
Okay, I just wanted to make sure I had the name right. I'm going to change your name up here. Have a report, right? Yes, ma'am. Okay. Wow.
So you have it, okay.
Yes,
Okay.
Our starts a long day. Ready on this one. Okay, calling case 2258125, People of State of Michigan versus Antonio D. Ward, charged with count one, weapons, firearms, possession by felon, count two, by felon, count three, weapons, felony firearm, count four, weapons, felony firearm, with the individual offender court defense notice set for a competency hearing today. Appearances?
Tanner Krueger on behalf of the people, P 86282.
Hey, good morning, Your Honor. May it please the Honorable Court, Rita Young, P 44626, appearing on behalf of Mr. Antonio Moore, who is present and standing to my right.
And clerk, please state your name, please.
Yes, morning, Antonio Dwayne Moore.
Morning. Okay, Attorney Young, you received the report?
Yes, Your Honor. I did receive a report dated March 23rd of 2023, and I will stipulate to attention.
Okay. That here that Mr. Moore was competent to stand trial at the time of the evaluation. You ready to set exam date or how do you move forward?
Yes, I would like to set my first exam date. And just for the record, he was also referred to criminal responsibility, but they indicated that that's going to take a little while longer, and that relates to defense of the trial.
Okay.
Thank you. See.
So, do you want to have an exam on the 15th or 16th?
I cannot, Your Honor, unfortunately, due to my obligations on other cases. But the 15th and 16th.
What about the 22nd or 23rd?
22nd started during trial, which will last through the 23rd. Sorry, Judge.
Thanks for the report.
Yes, I'm hoping that jury trial will be over by then. Yes, that would be right.
Okay. 10:30?
Yeah, that would be great.
So May 24th at 10:30. Or it'll be in person at 36 District Court, right back here at the courtroom, for May 24th at 10:30 for your preliminary examination, okay? Anything else we need to party?
No, Your Honor, thank you so very much.
Thank you.
And thank you to your staff.
You want to do that? It was much easier in person.
I'm sorry?
It was much easier in person.
Yes, it was. I like in person.
Yeah.
Pull.
Are we ready on Cedric Jones?
Yes, Your Honor. That's what I was just doing.
Okay.
Yes.
Please,
Just got one officer sent a damn on that.
Just one so far.
I mean,
You're on the record as the people of the state of Michigan versus Cedric Darrell Jones. Case 2355741, Mr. Jones is charged with 1 count of weapons carrying concealed set for a preliminary examination. Appearances.
Edwin Sawar, 54828, here on behalf of the people.
Morning, Your Honor, Alexander Cho with the Neighborhood Defender Service of Detroit, 885948, appearing on behalf of Mr. Jones, who is present for Mr. Jones, please state your name.
Cedric Jones Jr.
Good morning. Hey, I have a waiver form for me. Is it correct that your client, Attorney Shelton, will be waiving the exam today?
Yes, Your Honor.
Any objection from the people?
No objection, Your Honor.
Okay, Mr. Jones, I'm going to ask you a series of questions. If you can't hear me or if you don't understand, let me know, okay? And make sure you speak up for the court reporter when you respond, okay? Is it your wish to waive your preliminary exam today?
Yes.
You understand that you have the statutory right to exam?
Yes.
And that if you were to demand an exam today, the people will have to show as a probable cause standard, which is a much lower standard in criminal law, but still a standard, that one charge I read off was committed in Detroit, that you probably committed that crime. You understand that? Yes. And that by waiving your exam today, that means that people do not have to show anything or use evidence, prove anything today. You understand?
Yes, ma'am.
You also understand that you're not giving up your right to trial.
Yes.
Did anyone force you or threaten you to waive your exam? Did anyone promise you? Okay, I find a way to be free to understand and involuntarily given. Since you are out of custody, you're remaining on the information 2 weeks from today, that'll be May 25th at 9:00 a.m. Frank Marvin Hall of Justice. Okay? Anything else?
No, Your Honor.
No, Your Honor.
Okay, you're all set. Mr. Jones. Every day. Mr. Zimmerman.
Everyone say Your Honor.
You as well. Yesterday was the 10th. It wasn't a waiver.
He's fine.
See, that girl was- right? Waiver. I gave them that burn, I gave them the date of May 16, 1:30 for an exam. So this was, it's not a waiver. That's something. Yeah. That was not a waiver. I know that because you remember I talked to him on Tuesday for the waiver. This is the waiver. This was the airport. Yeah, right. So Tuesday he did a waiver. Remember, he's like, let's go rent room for the last. And then I told him Wednesday, you don't have to come. I'm gonna give you the date. Okay, okay. Okay, so now I need to figure out the waiver.
No, the waiver, I know the waiver, but it is not on the document on Thursday.
Right.
I do remember.
So that's just that for example. Let me,
Yeah, please.
Your Honor?
yes.
No, Sergeant Hyde wanted me to apologize on his behalf for being late. He's just getting
Is he
back.
here?
Yeah,
He
yeah.
come in if you want to. That's a problem. I mean, I appreciate it.
He just had a son, so he's, yeah,
He can come in if he wants to talk.
yeah, oh, let him know.
Yeah. Attorney Pearlman. Case 2355618, the people of the state of Michigan versus Andrew Quanted Love. Mr. Love is charged with with one count of weapons carrying concealed with habitual offender status. I've been noted set for a motion hearing today. Appearances,
Alexander Kirker on behalf of the people, P 86282.
Morning, Judge Jeff Pearlman on behalf of Andrew Love, P 80517.
and Mr. Love, can you state your name for the record, please?
Andrew Love.
Attorney Perlman, I received your motion. I'm pretty sure you're not going to like what I'm about to say, but after reviewing the motion and understanding procedurally what I would have to do after hearing the motion, I think it's best that send an exam, and if you have that same stance, then to, preserve or reserve that for argument after testimony has been provided and some evidence has been put out.
All right, so in other words, the court would hear, if the evidence presents itself, the court would address this motion, or I could address this motion at the exam as well.
Yes, as part of your argument, yep,
Okay, very well. That'll work.
okay. And I have read it already, so you don't have to go unless you want to for the record. I have read the motion. So I'm prepared to hear your argument after the exam.
Okay, very well.
Okay. So we see the date now. I can squeeze you in on the 16th. Or
Uh,
the 16th, or we can do after the 23rd of May.
Okay, the 16th of May. I have a trial that day. Let's see. Is the court available on the 20? Let's see, the 24th, then later in the morning.
So let me check.
Or actually, I'm sorry, that will not work. I apologize. The first, June 1st, or,
That works.
okay.
I don't have anything scheduled yet on June 1st. So what's that?
10:30?
That's fine.
All right.
Okay, Mr. Love, your exam has been for an in-person preliminary examination for June 1st at 10:30 at 36th District Court. You understand that?
Yes.
Okay, anything else from either party?
No,
Nothing for defense, Judge. Thank you.
Thank you for your patience today.
Have a great day.
You too. You're all set, Mr. Love.
all right.
Ms. Shelton, we're just waiting on your lawyer.
Yeah.
Is it witness here or just the attorney?
I don't know.
Okay. Yeah, I thought I forgot to check.
Yeah.
Should just give one second.
So you have to do this? Okay, on the record, this is the people of the state of Michigan versus Chris Dion Love, 2356496. Mr. Love is charged with count one, home invasion, first degree, count two, which is a misdemeanor, assault or assault and battery with habitual offender, second offense notice, set for a preliminary examination today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Okay, good morning to your court and to you, Emily Elijah, P 85039, as well as Mr. Bradford.
Cody Bradford, P 85944.
And Mr. Love, could you introduce yourself to the judge?
Chris Dion Love.
Ready to move forward?
They're not, Your Honor, are they necessary witnesses to appear?
This time, defense is dismissed.
And the complaining witness has been subpoenaed and notified and contacted, right?
That is correct, Your Honor. Our office did reach out and inform the committee with this was retained.
Okay, with that, information, I will dismiss without prejudice. The people are not ready to move forward without the complaining witness. Take long before. This is.
Do you need me to fill out the form? Thank you.
Okay.
Wait.
All right, Your Honor.
What is it?
Bring him.
Mr. Complaint witness, Mr. Lund.
The complaint witness for that case just showed up.
Yeah, I'll bring them all back.
Okay.
You can have a seat.
You can have it on that other load there. Yeah.
That's an agenda.
Okay. Is there anything?
Six, one.
I think everyone's important. Okay, we're back on the record on Chris Love, case 2356496. Mr. Love is charged with 1 count of home invasion, first degree, count 2 assault or assault and battery, the misdemeanor with a visual for the second offense notice, scheduled for an exam at 10:00 a.m. And I dismissed without prejudice at about 10:04. Planning which is not a present. Appearances.
Alexander Kirker on behalf of people, P86282.
Emily Elijah, P85039.
Morning again, Cody Bradford, P85944.
Chris Love.
Okay. And Mr. Herder is my understanding. Court officer of the district.
Yes, that is correct.
You have a request, or are you prepared to move forward home, or how would you like?
People are prepared at this time.
And anything from defense?
Yes, Judge, I think there are 2 issues in front of us. The first one is this court did enter a dismissal order, even if it was without prejudice. I believe that order to be a final order. I don't think we should just, take that back. So I don't think that this is proper at this time. I think the matter has been dismissed. And so the people will need to refile if they want to bring those charges. I understand this dismissed without prejudice, but nonetheless it was dismissed. So I don't think we can just go right back on the record.
You have a second?
I do have a second issue, and I'll defer to Mr. Bradford for that issue.
Judge, we, in addition to requesting it to be dismissed because you already dismissed it, there are discovery issues in this case. Ms. Elijah has reached out to the APA on May 8th, asking for missing body cam footage, which are the 2 officers who talked to the complaining witness. Those officers are Taylor Stevens and James Robinson. Again, Ms. Elijah yesterday on the 10th emailed the prosecutor who were still missing that information. After that, Ms. Elijah did email the court with a proposed order, just informing the court that we still had not received that body cam information. In this case, Judge, as in all cases, body cam footage is pertinent information for impeachment not only of the officers, but also of the complaining witness. We have reports in every case, and what the body cam footage is we look at. The body cam footage sometimes shows exactly what's in the report, and sometimes it shows opposite of what's in the report. Because we did not have that information, there's no way for us to impeach any of the witnesses that would testify today. I would ask the judge to look at MCL 780.316. The law requires that the police and the prosecutor keep all audio and video recordings until completion of a legal proceeding. I know DPD and the Wayne County Prosecutor's Office has a policy of after 90 days, it is wiped from their policy. They are welcome to have that policy. It goes directly against what the statute requires. 90 days, if the case is still ongoing, it's still ongoing. We need that information. Also look at MCL 780.318. That statute requires that all agencies that use body-worn camera to develop written policies for maintenance and disclosure of the audio and video recordings. Any policy that is written by the agency must comply with the statute. It very clearly says that. Looking at Detroit Police Department body-worn camera policy, section 304.6, subsection 3.3F says that if an officer determines that they are not going to activate their body cam footage, that they must, not may, must submit in writing the reason they decided not to activate their body-worn camera as the policy and the law requires them to do. We have no written statement why these 2 officers didn't turn on the body cam footage, and if they did, we still do not have that information. Because of that, Judge, the outcome for the police not doing this is they just get away scot-free every time. Nothing the defense can do can punish them. And candidly, nothing the Wayne County Prosecutor's Office can do to punish officers for not following policy and not following the law. So what is the consequence of them not doing that? As Mr. Love does not have a fair hearing because we cannot impeach these officers or any complaining witness. Because the law and DPD's own policy requires them to have this, and it would be unfair to Mr. Love, we would ask this case be dismissed for discovery violations.
I did reach out to the officer in charge regarding the missing body worn cam. I confirmed with her this morning, apparently she had responded to me, but those emails for some reason did not go through. The officer in charge stated that neither of those officers had body worn camera on that day, so that discovery does not exist.
Judge, looking at the written discovery, Taylor Stevens and James Robinson, it says body cam footage for Taylor Stevens is 135362. Body worn camera for James Robinson is 148254.
As an officer charged to put your appearance on record.
Officer Kimberly Stewart, Massachusetts, and Detroit. I do know that it does say the numbers, but I checked it Tuesday. I did not work yesterday, but Tuesday I checked it again on the website that we downloaded from, and there is no body camera footage for either officers on that ship on that day. So there's a glitch somewhere. The body camera may not have been docked. If it dies, sometimes it'll erase everything. There's nothing from either officers on that ship for that day.
So what Attorney Bradford is referring to is something that the investigator report stating that.
It's not an investigator's report, it's in the actual officer's report, that they put in their names and their body camera. And I looked up names, I looked up vehicle numbers, I looked up body camera numbers, and there's nothing on that day for those.
But because it's in the officer's report, it means that it existed.
On the camera, I can see they have a body camera, but in the actual system where I go to review them, there's nothing.
What I'm trying to ask is if you're an officer writing your report and you put in their body cam number, what does that indicate?
That you're issued a body camera, that it's the number right off the back of the camera. But what I'm saying is when I go to, like, they dock the camera, which this happens sometimes, it doesn't show up for a while. I don't know why, but I looked the other day, there's no footage on the cameras for that day. There's no, like, on the officers' names, there's nothing.
I'm not really getting the. I want to know whether it existed, not docked.
That could have been they weren't docked, or sometimes when they die, it deletes, like, the footage that was recording is deleted. I don't know. All I know is when I search the camera name, number, the officer's names, all of that, there's nothing there.
I want to see the document, but I don't, because maybe reissue, I might have to do it in case they had to look at officer report. And when officers have body cams, do they always put what is being recited today, Attorney Bradford, in their report?
They put their name and then the body cam number, and then they just, like, go through, like, what they told you what happened.
Okay, in this case, did they do that, saying that?
That's what they're reading off of, is the officer's report saying that that's the body cam number that they've issued, but it's not on the watch guard system.
Can you recite what it is that you have regarding body cam information?
Yes. The two officers that we do have body cam footage for. The ones we do not have are Taylor Stevens and James Robinson. Those are the two individuals who spoke to the complaining witness, did an interview, and this is one who then subsequently did these reports. Now, there are two issues that I'm hearing. They have in the report that there is body cam.
It said that there's body cam footage.
It literally says body worn camera right next to their name and their badge number with the body worn camera number. The second issue is that even if we knew for a fact that they did have body cam footage, the law and DPD policy requires them to give a written reason why they did not activate their body worn camera.
So what I'm trying to figure out is if they didn't activate it or not.
Right,
Whether-
there's no way for us to know that without.
Right. Having testimony or some type here. Because I don't know, what I'm trying to figure out, did they have it and not activated it? activated and not uploaded. I don't know.
I don't know for certain, Judge, but just looking at the report, it says that it did exist. Now, whether it was lost after that or they chose not to turn it on, I don't know, but I think the remedy for both of those issues is a dismissal based on the policy and what the statute says.
Okay, well, the first issue is that I dismissed it already. It's that issue. I'm trying to decide whether to dismiss it also based on discovery violation. I can't, Mr. Kirker, do you dispute that the report states that body cam footage should exist?
It just says the officer's name and their body cam number. It doesn't say that it exists or it doesn't exist. So what they do is that they're like Officer Taylor Stevens, her badge number, and then her body cam number.
Okay, so that means that they have body cam.
Yes, it doesn't say whether or not the footage actually exists, but there's nothing for either of that shift.
So that leads to, they had body cam on them, they didn't activate it or they didn't upload it or something. There was a body cam issue, and the body cam existed for a while. Okay, so I will add to the dismissal, the discovery violation based off of body cam footage being present and not being available for council to view the, or the people in that. Based off of whether it's a glitch or the officer's not recording or not uploading it, whatever it is that doesn't exist and it should exist based off of what I'm hearing. So, unfortunately, the complaint is a couple minutes late, but there's a second issue here of discovery. So it'll be dismissed. So,
No.
160-991. Mr. Jacob Maurice Cunningham is charged with one kind of retail fraud, first degree, second exam, appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. May it please this honorable court, Attorney Phyllis Gage Robinson, P 71733, on behalf of Mr. Cunningham. Your Honor, Mr. Cunningham is not present. I cannot account for his whereabouts. I did reach out to the number that I had for him as his contact number this morning at 7:30 and remind him to be here by 10 a.m. He did not respond. I called the number and apparently that is a friend's number. That friend has no way of contacting him, but indicated that when he saw him again, he would have him get in contact with me. So if he does get in contact with me, Your Honor, I am willing to walk him in.
Okay, that's what it will be, the warrant. You think the people?
People would ask for a KPS.
Okay, he has some KBS history, so it'll be 2,000 cash.
Thank you.
Anything else?
No, Your Honor. Have a great day. No, ma'am.
Should be three. It looks like Leslie Knapp. Should be it. Well, let me just double check the record. Let me check. Yep, Leslie Knapp.
Thank you, Mr. Silverman.
That's correct. Do you want me to call for that? Okay.
No.
I fixed it.
Just in case you need to call.
No, I'm sorry, that's not.
Your attorney name?
My other
Yeah, attorney's name.
Oh, Mr. Lowe.
No.
No.
All right.
What's your name? Najee.
Najee. Okay. So as soon as he's here, we'll start.
Okay.
Hello?
Ms. Shelton, we're waiting on your attorney to sign in. I'm gonna check with the judge. I've called her several times, but she's not picking up. So just hold on for a moment, but we're still here, okay? So place yourself on mute.
I was gonna say, I think, I'm not sure if this is her number, but I believe someone just tried calling me.
Okay, did you want to hang up and see if that's the person and then just call back in?
Yes.
Okay, we'll be here.
Okay, thank you.
Oh, it's no problem.
Bye.
you're on the record, is the people of the state of Michigan versus, is it Unaj, you said already, Unajah, Unajah Smith Henderson. Case 2305657-401. Ms. Smith Henderson is charged with one count of police officer assaulting, resisting, and obstructing with the habitual offender second offense notice set for an exam today. Appearances.
Edward Sawaki, B54828, appearing on behalf of the people.
Good morning. May it please this honorable court. Notice P42796, neighborhood defender service. Detroit, on behalf of Mr. Unaj Smith. Mr. Henderson, please tell me what you.
Unaj
Okay, I have a waiver form before me. Is it correct, Attorney Jones, that you're planning for your exam today?
That's correct.
Any objection from the people?
No objection, Your Honor.
Okay, Ms. Smith Henderson, I'm going to ask you some questions. If you don't- Questions, or if you can't hear me, let me know, okay?
Okay,
Okay, is it your wish to waive your preliminary exam today?
yes, ma'am.
You understand that you have a statutory right to a preliminary exam?
Yes.
And that if you were to demand that exam today, that people would have to show at the probable cause standard, which is a much lower standard in criminal law, but still a standard, that one charge I read off was committed in the city of Detroit, and that you probably committed that crime. You understand that? And that by waiving your exam today, that means that people do not have to prove anything today. You understand?
Yes.
You also understand that you are not giving up your right to trial? Did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you? Okay, I find your waiver to be freely, understandingly, and voluntarily given. You will be bound over to Frank Murphy Hall of Justice for an arraignment on the information. The date will be 2 weeks from today, May 25th at 9:00 a.m. Anything else for you to argue?
No, Your Honor.
Your Honor, I'd simply like to address the matter of the bond.
Sure.
Ms. Henderson is wearing a tether, which doesn't seem appropriate given the nature of these offenses. She has one previous felony offense, which was uttering and publishing. And in the instance of this particular case, this arose out of a dispute with her neighbor who has previously called the police on her unjustly. And she was trying to get into her car when the police officer tased her, which then caused her foot to hit the gas and drive off. Otherwise, she would have simply remained there. So I'm asking to have the tether removed. She's a lifelong Detroiter, and she has no history of assaultive behavior.
Yeah, people would object. This is the charge we're here for today is assaulting a police officer or officers. She didn't just slip, she ran into a police car, garbage, and no parking after she was tased and after she refused to obey the police officers. And she kept trying to get away by putting the car into drive, trying to put the car to drive, and the officer kept taking it out until she finally got away from it. So this is a serious charge. We think that tether is appropriate.
Your Honor, if I may, just one last thing. It's doubtful that Ms. Smith Henderson will ever again try to assault or resist or obstruct an officer or to escape from this. This all happened in the vicinity of her own house, in her own driveway. She's not a danger to the community, and she certainly isn't a flight risk. She has a full-time job here and intends to show up for court just like she did today.
Where do you work?
I'm a carporting company.
A carporting company?
Yes, I started there today in Dearborn.
Okay.
Where 6:30 p.m. to 6:30 a.m.
Overnight?
Yes.
Okay, night shift. Let me be changed anyway. Your curfew was. Yeah. I will allow for the tether to be removed. Ms. Smith Henderson.
Yes, ma'am.
Let's see here. You don't have any cases history. That's the only reason why. misconduct today, you are employed, you have stable records. So I will allow the defendant to be removed. I don't have jurisdiction after today, so if you somehow don't show up to court, judge may do something a little bit different. Okay, so just make sure you show up to court, follow instructions from the next judge as well, okay? Yes. So I will have the tether removed and just continue to work and show up to court. Okay, I would say no contact without there's no civilian witnesses. And I don't think there's any relationship between officers, right? Okay, all right. So I have that word throughout.
Thank you.
Thanks. Some judges make you wait, some judges put it in the system and take care of it. Okay. Thanks. Appreciate seeing you, man. You just got to move it down there.
Ready on Terry Williams and Mr. Welch.
Ready, Your Honor.
Ready, Your Honor.
Ms. Shelton has been on here since 8:30. I told her, what should I do? Ms. Shelton, before we call Mr. Williams and Mr. Welch, Ms. Shelton, can you unmute your device?
Yes, I'm here.
You've been here since 8:30. You are supposed to be, you actually didn't enter the warrant from yesterday, so I don't have to arraign you. What I'm gonna do is just set your exam date, and your attorney needs to appear as well. So I don't want you to have to sit here any longer and wait, okay?
Okay,
So your exam day will be May 16th at 1:30 p.m. in person at 36th District Court.
okay, thank you.
Wait a second, hold on. I have to hear this. Ms. Shelton?
Yes,
Okay, so that was the wrong date. It's May 15th at 9:00 a.m.
okay, thank you.
Person at 36th District Court.
Okay.
All right, have a good one.
You too.
Okay, now back to Mr. Welch and Williams. This is case 2355520, the people of the state of Michigan versus Terry Williams Jr., who was defendant number 1, and William Blake Porter Welch, who was defendant number 2. Both are charged with count 1, conducting criminal enterprises. Both charged with count 2, stolen property, receiving, concealing a motor vehicle. Both charged with count 3, attempted larceny from a motor vehicle. Defendant 1 is charged with count 4, 5, 6, 7, 8, 9, which are all stolen property, receiving and concealing a motor vehicle. Defendant 1 is charged with count 10, weapons, firearms, possession by a felon. 1 is charged with count 11, weapons, funding firearm. Defendant one has a habitual criminal record. The fifth notice, today is the date set for a preliminary examination for both defendants' appearances.
Good morning, Your Honor. Gregory Blackburn on behalf of the people.
Morning, Your Honor. Joseph Arnone on behalf of Terry Williams, defendant one, P68572.
And good morning, Your Honor. Jason Malkowitz, P61242, on behalf of Mr. Welch, who is present via Zoom.
And Mr. Williams, can you state your name for the record?
Terry Williams.
And Mr. Welch, can you state your name, please?
William Welch.
Thank you. Okay. I received an email that today both defendants will be waiving their exam. Is that correct?
On behalf of Mr. Williams, that is correct, Your Honor. I have advised my client he has a statutory right to a preliminary examination, that it would be a probable cause hearing where the people would have to show probable cause that these offenses occurred, probable cause that he committed them, or the matters would be dismissed. He is inclined to waive his right to a preliminary examination and have this matter be bound to the circuit court for arraignment on the information.
Thank you for that. And Mr. Williams, did anyone force you or threaten you to waive your exam today?
No,
Did anyone promise you anything for you to waive your exam?
no,
Okay, any objection from the people for the waiver for
No,
Mr.
Judge.
Williams?
No, Judge.
Okay. Okay, I find your waiver, Mr. Williams, to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, for your arraignment on the information date of May 25th at 9:00 a.m. That's exactly 2 weeks from today.
okay.
And for Mr. Welch.
Your Honor, Jason Malkowitz on behalf of Mr. Welch. This is also going to be a waiver, but we do have an agreement where count one against Mr. Welch, the criminal enterprise, will be dismissed and he will be waiving up on the remaining counts.
Okay, is that correct, Attorney Blackburn?
That is correct, Judge. The people will be moving to dismiss count one against Mr. Welch, only the criminal enterprises count. He will be waiving on counts 2 and 3.
Okay.
And Your Honor, on behalf of Mr. Williams, there was consideration. We intend to resolve this matter in the circuit court as well.
Okay, thank you for that. Okay, Mr. Welch, can you hear me?
Yes,
Okay, I'm going to ask you a series of questions. If you don't understand me, if you can't hear me, please let me know and I'll repeat the question or explain it to you, okay?
yes,
Is it your wish to waive your preliminary exam today?
yes,
You understand that you have a right to a preliminary exam?
yes,
That if you were to demand that exam today, the people will have to show us a probable cause standard, which is a much lower standard in criminal law, but still a standard, that the charges I read off that were associated with you were committed in the city of Detroit and that you probably committed those crimes. Do you understand that?
yes,
And that by waiving your exam today, that means that people do not have to prove anything today. You understand?
yes,
Understand that you are not giving up your right to trial?
yes,
Did anyone force you or threaten you to waive your exam?
no,
Did anyone promise you anything outside of any offers from the people?
no,
Okay, I find your waiver to be freely understandingly and voluntarily given as well. And your arraignment on the information date will be the same, May 25th at 9:00 a.m. Frank Murphy Hall of Justice. I am not sure if it's on Zoom or in person. APA Blackbird, do you know?
I believe all the AOIs are in person now, Judge, but I will confirm with whatever AOI judge Mr. Williams and Welch are assigned to.
Okay, so I will dismiss count one as part of the waiver, and I will have that dismissal in the file, and he'll be going over on counts 2 and 3 for Mr. Welch. For all parties, do I have your permission to sign the waiver forms since you all are all remote?
You do, Your Honor.
Yes, Your Honor.
On behalf of Mr. Williams, yes, Your Honor.
Okay, anything else from any of the parties?
Yes, Judge, in regards to Mr. Welch, given that the most serious crime against Mr. Welch was just dismissed and there are only a couple lesser felonies against him, Judge, I'm asking the court to consider removal of the tether Right now, Mr. Welch is only charged with a larceny from a motor vehicle charge. He's no longer charged with the CCE. He's not charged with any of the felony firearm counts. There hasn't been any allegations since his time out on bond of any non-compliance with the tether. He's on probation in Macomb. He is reporting there. There haven't been any issues with that. I would ask the court to consider removing the tether.
AJ Blackburn.
Judge, I would just only point out that Mr. Welch is charged as a habitual fourth offender. He does have a lengthy criminal history, including some violent offenses. But other than that, I don't have any information that there's been any subsequent violations of his tether or anything like that. So ultimately I'd leave it in your discretion, Judge.
Okay, let me check a couple things in this file. It's a pretty thick file here. Okay, I don't see any cases history. That was the one thing I was concerned about. There are no violations from my understanding from what I see in the file. So I will allow for Mr. Welch to have his tether removed.
Thank you, Your Honor.
You're welcome. I have to submit an order that we submitted as well to the tether unit.
Thank you.
Okay, anything else?
Nothing further.
Nothing from the people, Judge. Thank you.
Nothing on behalf of Mr. Williams. Thank you.
All right, everyone take care.
Have a good day.
You gotta leave this.
Let me help you out. Okay. Jasmine Thomas,
Yes, I'm here.
good morning.
Good morning. How are you?
I'm fine. How are you doing?
I'm okay. A little frustrated. I couldn't get the bus routes down, but I'm okay. I'm fine.
So you have an exam in person today. You do know that, right?
Yes, I tried to get there, but I don't know which route of the bus is to catch, and I end up getting lost, and I had to walk to my auntie house. But I just spoke with my attorney because I know I was supposed to be there in person, and she told me to just join because I didn't want to just not show up at all.
Okay, that was a smart thing to do. Okay. Let's see. Who's gonna call your case and we'll go from there, okay?
Yes, ma'am.
Can you turn your camera on?
Yes, I'm learning. I'm sorry. I'm trying right now.
Come over and you said you're driving? Oh, okay, I thought you said driving. Here. Said trying. Okay. Driving. Okay, we're on the record. This is people of the state of Michigan versus Jasmine Thomas. Case 2257933. Ms. Thomas is charged with 1 count of assault with a dangerous weapon. Felonious assault set for a preliminary examination today at 11 o'clock? Yes. 11 o'clock. Okay. Appearances?
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. Leslie Knapp, 34696, appearing on behalf of the defendant. It's nice to finally meet you and your staff in person.
Yeah, I was thinking the same thing.
Yeah. Turns out that I used to work with Ms. Carson's father. So we had some memories going back out there. So I know, I'm sorry.
No, it's a good person.
It is. Your Honor, if I may, I spoke to Ms. Thomas yesterday, so I knew she was supposed to be here. I called her, she did tell me she'd gotten on the wrong bus, was very confused about where to go, and given the situation, I suggested Cindy would be the best option for her. Because I believe Mr. Kirker has something to say.
What is that?
I've spoken to the officer in charge who talked to the complaining witness who no longer wishes to proceed.
Okay.
I would ask that the case be dismissed, Your Honor.
Okay. And Ms. Thomas, it's not that you did try to get here in person. I understand your confusion or frustration with trying to catch the bus here.
Yes,
So,
ma'am.
Based on the information that the people have provided, I will dismiss without prejudice your case today as the complainant witness is not present, does not wish to prosecute.
Okay.
Your Honor.
Good luck, Jasmine.
Thank you so much, Ms. Knapp.
You're welcome, honey. Did you post a bond?
They gave me a personal bond because
Okay,
I've never
you're
been
all-
in trouble before.
Okay. Okay, you're all set. Just make
Thank you
sure
so
you get
much.
home safely.
Yes,
You're welcome.
ma'am. Yes, ma'am.
Okay, bye-bye. Thank you.
Bye.
Seems to make her cry.
Okay, we are on the record. This is the people of the state of Michigan versus Tavares Eugene Brooks, 190527801. Mr. Brooks is charged with one kind of controlled substance possession, narcotic or cocaine, less than 25 grams, set for a walk-in arraignment. Appearances?
Alexander Kirker on behalf of the people, P86282.
Good morning again, y'all. Edward Taylor, appearing on behalf of Mr. Brooks. My P number is 357-166. Mr. Brooks, would you introduce yourself to the court, please?
My name is Sabree Eugene Brooks.
Okay, for arraignment purposes. Mr. Taylor?
Yes, well, question. Stand be waiting for reading, all right?
Okay, I'll enter not guilty. The register of actions shows here that Mr. Brooks was to appear on the 3rd for a probable cause conference, never appeared.
Mr. Brooks got confused on the date. So from now on, I got it right number. I had his mom's number, so I couldn't contact him directly. is right now, so. we'll get that communication, sure.
Now, the next question is, why is he here at 11:30, not 8:30? Mr. Brooks?
I slept, I was working last night late. I was slept.
You think that's sufficient? I appreciate the truth. So I'm trying to understand because I have to set a bond now. And I'm trying to determine what I should do based off your willingness to come to court, whether or not I believe you actually show up.
I'm sure.
How do I know that?
Give me a chance, and I should prove it to you.
Again?
Give me a chance and I'll prove it to you.
Okay, because I gave you a chance today for 8:30. You didn't call the court. Your attorney came here at 8:30. He has somewhere to be. So you wasted his time, our time as well. You understand that? This is a felony charge. This is not a traffic ticket. This is not a speeding ticket or parking or littering. This is a felony matter. Not saying those cases aren't important, but you need to be here. Another judge could have easily just put in a warrant, 5,000, 10,000 cash. You would have been over Wayne County Jail. You understand? Okay. So, Attorney Taylor, do you have discovery?
I do.
Okay, so we don't have to go through a PCC unless we can put one in the calendar so that discovery can be sent. Is that how it works?
Yes.
Okay, so I can schedule a PCC for tomorrow, but you all don't have to show up. It's just so that the system will automatically send out.
Do I have to zoom in?
No, you don't have to do anything.
Okay, all right.
You don't have to show up either, Mr. Brooks, tomorrow.
That's good.
It's just going in the system so that the process can move forward for your exam. Okay? So, as far as the exam day, let's get one. How about May 22nd?
I have something at 11, but that should be good.
How about 1:30?
1:30 is good.
Mr. Brooks, your exam has been set, May 22nd, 1:30 p.m., right back in the course, okay? That's the next date, you don't have to worry about tomorrow, okay? Anything for people?
Nothing.
Okay. And bond wise, it'll be set back, I don't know what your, it was at $1,000 cash and surety, so I'll put it at 5,000 person.
Thank you, God. I'll make sure Mr. Brooks is here at 1:30 on the 22nd.
Okay, maybe even 1:15.
Yeah, he'll get here early, I
Okay,
think he's got his lesson. Thank
okay,
you.
we're off the record.
Thank you.
Anybody on the 11:30?
No. Nothing. There's no issue with that on the TV.
Sorry, y'all, good morning.
Good morning, Judge. Can I have a breakout room with my client?
Absolutely.
Thank you.
William,
Good morning, good morning.
Room with your client, with your attorney, go ahead and unmute your device when you can, so that you can speak to your attorney in private. For David, I'll be.
So Judge, we're having technical difficulties from the facility. They can't unmute him.
Oh, okay.
I called out the officer's name and the case and the defendant name and all that. Officer's name.
All right.
You may have to close the breakout room. I had that before.
Let's see, hold on. Officer Carson. Thank you. It's unmuted, so I don't know what. Oh? Yes. Mr. Williams?
Can you hear us? Can you hear? Yeah,
We can hear you.
we're not showing that we're muted. It's showing that the attorney had us muted on her end.
It
But I
couldn't have
don't,
been me. It could not have been me.
It
It's the
showed
court
on-
that puts us in breakout rooms.
You want to go back to the breakout room, Attorney Diallo?
I would, because I couldn't hear anything. So I'm not muting anybody. It would be the court because it's a breakout room that I was in. I don't know how it happened, but thank you so much.
Yeah, it would have been the court. Who will come back? Okay, Attorney Diallo.
We're ready. Thank you.
Okay. This is the people of the state of Michigan versus Demetrius Williams, case 2155010. Mr. Williams is charged with count 1, weapons, firearm, possession by a felon, count 2, weapons carried concealed, count 3, weapons, felony firearm, with the habitual offender second offense notice set for a preliminary examination. Say appearances.
Alexander Kirker on behalf of the people, P86282.
Judge, good morning to you and your staff. Lillian Diallo, P52036, on behalf of Mr. Williams, who is present via Zoom technology with consent.
Mr. Williams, state your name for the record.
Demetrius.
Okay. I think ready to proceed.
Your Honor, the necessary witnesses have come here.
Motion to dismiss.
Okay, the time is 11:53. The exam was set for 11:30. The people cannot move forward. Dismissed without questions.
Thank you, Judge. And if I can just go back into a breakout room with him and then I'll leave from there so I can explain them what happened. Thank you so much.
You're welcome.